On Capital Connection, Governor Pritzker declares Illinois the most progressive state in the nation when it comes to abortion.
We proudly proclaim that in this state, we trust women.
How the new law here contrasts with restrictions in red states. Plus,
I think they're going to tell you it's balanced.
Why the state's top fiscal officer won't say Governor Pritzker's budget is truly balanced, and how she's reimagining her role in public life after losing the election for mayor of Chicago. And
he came out of the gate with a huge minimum wage increase that small businesses aren't going to be able to pay.
What lies in store for business owners after radical changes come to the land of Lincoln? Todd Meisch from the Illinois Chamber of Commerce joins us. And joining us on our Reporters Roundtable, Rebecca Anzel from Capital News, Illinois, and Jaclyn Driscoll from NPR, Illinois. It's all coming up on Capital Connection.
From the Illinois State Capitol, this is your Capital Connection.
Welcome to Capital Connection. I'm Mark Maxwell. Governor Pritzker signed a bill into law on Wednesday, the controversial Reproductive Health Act. It expands access and adds protections and removes penalties for abortion in Illinois. The governor now declares Illinois, quote, the most progressive state in the nation on abortion. This comes at a time when other states across the country are restricting access to abortion as much as 4 to 6 weeks after pregnancy begins, even in some cases where rape or incest had occurred. Already, Republicans across the country are pointing to this new law in Illinois to fuel their campaign to run for Congress in 2020. But Democrats point to those red state restrictions as the very reason why they passed the law to protect access to abortion here in Illinois. All of it to prevent anyone from ever banning a woman from seeking access to abortion in the land of Lincoln.
Abortion bans don't ban abortion. They just endanger women.
Governor J.B. Pritzker signed the Reproductive Health Act into law Wednesday morning, pushing the state farther left when others are moving right.
In a time when too many states across the nation are taking a step backward, Illinois is taking a giant step forward for women's health.
Other states are in a race to pass the most extreme restrictions and get those to the Supreme Court.
There is a war against women, a war on bodily autonomy.
House Democrat Kelly Cassidy led the charge in the House and said abortion opponents misconstrue and malign abortion with, quote, misogynist rhetoric.
At our very doorstep, in 11 days, the people of Missouri will find out if they will lose the only clinic in their state.
Missouri is one of several states with just one abortion clinic open. Pending a court ruling, it could be forced to shut down, making Missouri the first state in the nation without legal access to abortion in 46 years.
As a result, more and more Missouri women are being forced to travel to Illinois and to Kansas to exercise their rights and access care.
Several other Republican states across the country passed near total bans on abortion, putting strain on the landmark abortion case Roe versus Wade.
And the Reproductive Health Act ensures that women's rights in Illinois do not hinge on the fate of Roe v. Wade or the whims of an increasingly conservative Supreme Court in Washington. And in Illinois, we guarantee as a fundamental right a woman's right to choose.
And we turn now to our Reporters Roundtable for insight and analysis into the Reproductive Health Act, what's in it, what it does, how it passed. Jaclyn Driscoll joins us from NPR, Illinois, and Rebecca Anzel from Capital News, Illinois. You may have seen some of her coverage in newspapers across the state, part of the new Capitol Bureau here in the State House. First of all, from a technical standpoint, what's in this new law?
As simple as possible. I'll let Rebecca do some of the details because she's covered it more than I have, but it treats abortion care, abortion services like any other health care. So that's the primary basis of it, and we heard Kelly Cassidy say that a lot in floor debate.
What does that mean? Because I guess to understand that, what that means now, you have to understand that in the past, laws on the books didn't do that. In fact, they explicitly had entire code written around abortion. What's different about it now?
Right. So previously, in certain areas of the law, it was written into the criminal code. Doctors could have been charged with certain criminal penalties for performing abortion. That was all stricken from the law. There were spousal consent aspects of the law where a woman would have needed her spouse's consent before getting an abortion.
So it was on the books. The court said you can't actually enforce that.
Right. Yes. There were other aspects of the law that were also tied up by courts that were all knocked out. The law took all of those things. This new law took all of those statutes off the books. It also requires private insurance companies, if they cover pregnancy benefits, to also cover abortion services. There's some cost sharing involved in that too. So if they require co-pays, let's say, for pregnancy benefits, requires those things for abortion as well.
So these are all ways in which the courts have had to intervene with private disputes between insurance companies. And so what was the purpose, I guess, of going back? And if those things were on the books, they essentially picked up those stack of papers and threw them in the trash can. Why do that? What was the angle from the supporters?
So, as we've seen in other states, some more conservative states, primarily in the Southeast, Georgia, Louisiana, Ohio, Missouri, have most recently passed abortion restriction laws. They're doing this in some part to challenge Roe v. Wade at the Supreme Court of the United States. There's some thought that if Roe v. Wade is overturned by the Supreme Court, the parts of Illinois law that before they were overturned, that were enjoined, if Roe v. Wade was overturned and somebody challenged those aspects of those laws, the Seventh Circuit here could have re-examined those enjoined statutes and reactivated them, so to speak.
So the doctrine penalties could have been revived?
Yes.
Or other parts of that law. Interesting. I want to get some reaction. So we heard from the supporters, but after that press conference, there was also some critics of this from the Roman Catholic advocacy group, the Thomas More Society. Peter Breen, a former House Republican, was at that press conference. Here's part of what he said in a response from Kelly Cassidy.
What happened today was the legalized killing of viable, preemie babies in utero.
We have a viability standard in the law, and federal law with regard to abortion late in pregnancy reigns supreme. So there is nothing in this law that will make that scenario possible.
All right, to Peter Breen's comments there, he said the legalized killing of viable preemie babies in utero. What does he mean there exactly in the clinical sense? And Kelly Cassidy saying the federal law reigns supreme. Do we know how the state law and the federal court decision interact here?
I want to address Peter Breen first. What he's saying is the question of viability is there's no statute. We can't put in the law what a viable baby is. It's usually around, I think, 22 weeks. The viability means it's able to survive outside of the womb, but that judgment is up to the licensed physician. And we heard a lot of testimony on this in floor debate from a very pregnant Avery born saying that there are no standards for viability. If there is an abortion clinic that is set to profit from performing abortions, they could find some way to say that that child is not viable. But it's important to know that the RHA is setting this up to treat abortion like any other health care. So it's between a woman and the doctor to best decide whether that fetus is viable outside of the womb. So that's the question that he's posing there.
And then when she says we do have a viability standard, he says there's not one. Is there a way to analyze the law and look at this? I understand there's going to be partisans and politicians here, advocates on both sides who are going to try and make their case. What's in the law, and how does it interact or interplay with Roe versus Wade?
There is a definition of viability in the RHA. A lot that's come up is people who oppose the RHA have said that it allows for an abortion to occur at any point up until birth. Proponents of the RHA have said that that's not the case. RHA has stricken something called a partial birth abortion ban.
And you're not using that in the political rhetoric sense. That's the actual name of the law.
That's what it's actually called. It was in Illinois statute. It was enjoined by the courts. That was repealed by the RHA. There is one that exists at the federal level. Of course, the federal level, any laws that exist at the federal level supersede that of the state government. And so because that exists at the federal level,
for now.
The state of Illinois has to follow that. So that still exists at the federal level. The state of Illinois has to follow that. The RHA does not supersede federal law.
All right, Rebecca and Jaclyn, thanks for joining us.